Wait, you forgot to notarize your will and now it's invalid? Or is it? This one mistake confuses more Georgia families than just about anything else in estate planning. And if you get it wrong, your family could be dragged through a stressful, expensive probate process, all because of one missing stamp. So let's clear this up once and for all. Now, you might think, I've got a will, I'm good. But if that will isn't executed properly, or if you're missing one critical step, you could leave your family stuck in legal limbo, hunting down old witnesses, or worse, watching your wishes get challenged in probate court. Here in Georgia, the rules are different than you might expect. So let's talk about it. Does a will need to be notarized in Georgia? What happens if it's not? And most importantly, how do you protect your family from chaos down the road? Let's break it down into two parts. No, a will itself doesn't need to be notarized in Georgia, and that surprises a lot of folks. Under Georgia law, a will is legally valid without a notary as long as these 5 requirements are met. The person creating the will, the testator, must be at least 14 years old. Yep, 14. Georgia has the lowest age in the country. They must be of sound mind. That just means they understand what they're doing and haven't been declared legally incompetent. The will has to be in writing, no video wills, no verbal promises, and must be typed or handwritten. It has to be signed by the testator, and it must be witnessed by 2 people. Those witnesses also have to be at least 14 years old. That's it, no notary required. But you absolutely need a notary for this critical step, and here's where things get important, the self-proving affidavit. Think of it like a VIP pass for your will. Without it, when the person who made the will passes away, the court might require the original witnesses to appear in person and swear that they saw it signed. That could be decades after the fact. But what if those witnesses have moved away or passed away themselves? Now your family is in a legal jam, trying to track down missing people, hiring lawyers, attending court hearings, all during one of the hardest times in their life. I had a case not long ago where a daughter brought in her mother's beautifully written will. Signed, witnessed, everything looked great, but no self-proving affidavit. We spent 3 months tracking down a witness who had since moved to Oregon. The probate court wouldn't move forward without her testimony. Meanwhile, assets were frozen and the family couldn't access funds they urgently needed. All because one simple step was skipped. What's the solution? Here's what you do. When you sign your will, attach a self-proving affidavit. The testator and both witnesses sign it. A notary certifies all 3 signatures. That's the part that does require a notary, not for the will itself, but for the affidavit that backs it up. This 1-page document can save your family months of heartaches. So let's recap. You don't need a notary for a valid will in Georgia, but you absolutely should notarize the self-proving affidavit that goes with it. That one step makes your will court ready and spares your loved ones from needless stress later on. If you already have a will, double check that it includes a self-proving affidavit. If you're creating one now or need to update an old one, we can help you get it done the right way. Because estate planning isn't just about documents, it's about peace of mind for the people you care about most. Book a free consultation. Bring your questions. Let's make sure your legacy is protected the way you intended.